before I miss it, your statement at the beginning is so timely. You said that the UPHOLD XRP debit card is live in the UK. Well, you probably haven't had time, Doctor, but in the amicus brief that I filed yesterday, I cite the UPHOLD card as an example.
Hi everyone, welcome to Token Topics. XRP, Attorney John Deaton, and the SEC lawsuit are the topics. We're going to hear words from John Deaton as he was just interviewed by Dr. Martin of UPHOLD. Also, we're going to look into central bank digital currencies and the Digital Euro Association. Please hit the like, share, and subscribe. Remember, I'm not a financial advisor. Let's go ahead and dig in. I'm going to go over a couple quick articles and then we'll dive into that interview. But if you like, you just fast forward. So Coinbase, this is big. They filed an amicus brief yesterday. They're arguing that the SEC's XRP lawsuit caused $15 billion in losses for retail investors, traders. Crypto exchange Coinbase has filed an amicus brief in support of Ripple, arguing that the SEC's lawsuit led to the retail traders losing $15 billion. That's crazy. According to the exchange, the SEC's action forced U.S.-based exchanges to delist XRP, causing the retail customers significant losses. The coin's market cap declined tremendously. If you'd like to go over the rest of this article, I'll put the link down below. All right, we know XRP is vital for central banks around the world, and what Ripple is doing is connecting this entire ecosystem. Ripple has set the standard for IPL, or Interledger Protocol, and I would say a major part of their protocol is interoperability, a bridge asset, better to say. Now, throughout all these payment rails throughout the world, XRP in some way, shape, or form will bridge central bank digital currencies, along with other assets talked about on this channel. And here we can see the Reserve Bank of India is now working on a central bank digital currency. So this is a good sign to see that utility is at our doorstep. So we can see right here, the digital rupee is going to be reality, and it's working with 9 banks. And as you can see from the second paragraph, the use case for this pilot. And you can see it says cross-border payments will be the focus of future pilots based on the learnings of this pilot program. Cross-border payments and settlement. So this is posted from the Digital Euro Association. Great info. October's passed. It's time for questions of the month. We asked the DEA community of which kind of technology central bank digital currencies should be built. 45% of the respondents believe that blockchain or distributed ledger technology would be most suitable. As you can see from this chart right here, so based on what kind of technology should a CBDC be built? As you can see right there from the graph, 45% said distributed ledger technology, 6% said other, and 42% said a combination of distributed ledger technology and conventional. And another 6% said conventional central bank infrastructure, meaning the traditional, the legacy systems. Now, why is this significant? What does this mean about Ripple? Well, that's a good question. Considering the Digital Euro Association was just referring to distributed ledger technology, a whopping 45% voted for it. 42% voted for distributed ledger blockchain technology along with legacy systems. So that is vital, considering that Ripple tweeted out earlier this year that we're excited to join the Digital Euro Association as supporting partner to further develop our work with central bank digital currencies. In other words, the majority of the DEA community is ready for utility.
Because when the SEC filed this case against Ripple, but not just against Ripple, they claimed all XRP, no matter who sells it, that it's a security, an unregistered security in the United States. And I just simply said that that's absurd. That's not what the law says. Something as bad is happening here. And I filed a lawsuit against the SEC, and it went viral, and then people just joined. And so in the last 18 months, or actually a little bit longer than that, 75,000 people from all over the world. I know you have international audience, UK members, 143 countries, Doctor, 143 countries have joined and represented. So when I say represent, it's not in a legal retainer kind of format. It's more of I represent their interests because we all share the same common interests.
it is not a class action lawsuit either.
Well, what I did is I filed what's called a putative class. When I filed the case against the SEC, it was in the name of individuals, 6 individuals, but I did put and all others similarly situated. And then what happened is we went to the New York Southern District where the Ripple case is, and I filed a motion to intervene. And I filed it as a putative class action. Basically, at that point in time, we had 12,600 people join. And so I went to the judge and simply said, look, these charges by the SEC, they're not just against Ripple. They're against every XRP holder in the world. And therefore, we should be in this case and we should be heard and we should participate. And the judge agreed. She didn't agree to make us defendants. She wasn't going to force the SEC to start naming us as actual defendants. But what she did is said, I'm going to allow you to be amicus curiae, which simply means a friend of the court, where she will allow me to file briefs and things of that nature. And before I miss it, your statement at the beginning is so timely. You said that the UPHOLD XRP debit card is live in the UK. Well, you probably haven't had time, Doctor, but in the amicus brief that I filed yesterday, I cite the UPHOLD card as an example.
There you go. The most timely webinar ever.
The reason why we're here is that because there's been so much uncertainty, right? The U.S. securities laws that we apply in the United States come from 1933. And there was a case in 1946 that defined what a security and an investment contract is. And as you can imagine, Doctor, if you're applying the law from the 40s to today involving technology, the digital assets were not envisioned. So we're trying to apply that 1940s law to modern day technology, blockchain technology, and it's not an easy fit. And so it has allowed there to be this uncertainty. And the SEC is trying to take all of the jurisdiction. They don't want the CFTC to have it. They don't want Treasury to have it or FinCEN. They're saying that all of these tokens are securities. And they're using this Ripple case and the XRP case as a way to try to establish that jurisdiction. In the brief, I write that people are being victimized because the SEC is engaging in a jurisdictional power grab, right? They're saying all blockchain is us. We regulate it, and they're using this case, and so people are with their pitchforks are going to the SEC saying, that's silly. That's nonsense. You can't claim that the token holder in the UK, whose financial administrator has said that XRP is not a security, that it is a security. You can't reach your jurisdiction into our country. And that's what they do. The SEC is so arrogant that they're trying to supersede foreign regulators. Doctor, as you know, XRP has been deemed a non-security in the UK, in Singapore, Switzerland, United Arab Emirates, everywhere, Australia, all these places. And so it's the SEC trying to be like, get their greedy hands on this industry.
Okay. Do I get the sense that, for example, in the last few weeks, the CFTC seems to be more powerful or more engaged? Why is the state here?
Well, that's a great question. It's because Congress is broken, because there's so much division. Congress is not enacting. The CFTC is being more vocal now, but what you have is if you take XRP, what people don't know about XRP is the first regulated digital cryptocurrency in the United States. In 2015, FinCEN declared it as virtual currency. But the problem in the United States is you have, I think 9 different agencies that could claim some type of jurisdiction over this asset. And unfortunately, Congress has not come together. And basically, as you said, eloquently went back to the drawing board and carved out legislation that protects consumers and people, but at the same time fosters innovation. They haven't done that. And in the meantime, you have all these agencies trying to figure it out by themselves. And so, and unfortunately, we have a chairman at the SEC who is being very aggressive over the industry.
And can we move forward, or do we have to wait until we have a definition? How do we build working in a vacuum?
I know that there's obviously, I think there's been a total of 8 bills proposed in Congress. Right now, the first thing in the United States that has to happen are the midterm elections, which are basically, coming up in a few days. And that will dictate a lot what happens. Nothing's going to happen this year. This year is coming up. We're in November 1st. So that has to happen. Once we know the makeup, for example, do the Republicans take over the House and the Senate, or do they only take over the House? How divided is the government going to be? But once we get into early next year and we have the new Congress and the new Senate, I hate to be a pessimist but Congress is not done its job. And I believe this Ripple case will be decided before we receive any congressional legislation. But at some point, you would think that they would get off their butts and do their job, because Democrats like crypto, Republicans like crypto, independents like crypto. So there's no reason that it won't happen. There have been talks of what you're saying that's going on in the UK. There have been talks of creating a separate agency, and then there's talks of the CFTC having control, but maybe there being a subcommittee of the CFTC that controls digital assets. But we'll see. It's not going to happen in the next 6 months to a year, unfortunately.
And I mean, we are reinventing the world's financial system. It ought to take a bit more time to do it properly, right? Absolutely. You were in the news this week saying that what might be good news as the big day approaches. What's the big day? What's the good news this week? What happened with the SEC?
Well, what happened is yesterday I filed the amicus brief for XRP holders and those 75,000 people that we've been talking about. We got to file our brief, and I should make it clear that as of right now, it's an application to the judge to accept the brief. But it's been filed. The brief's been filed that I alluded to that brought up the UPHOLD debit card. And that's something where for the last 2 years, XRP holders haven't had their voice. But that brief that I filed yesterday is their voice being given to the judge so that she can understand from our perspective of why she should rule a certain way. And the way she should rule is deny the SEC's motion for summary judgment, which simply means that the SEC wants to win, that they lose the legal case, and that Ripple win the legal case, and that XRP is deemed not a security. Coinbase came out and filed an amicus brief yesterday as well. And after that, a couple others got.
What is an amicus brief saying? Like a pen pal. What is an amicus brief?
Sure. And that's a great question. The amicus stands for friend. And so it's basically when an organization or a group of people say to the court, your decision is going to impact us greatly. It's not just about Ripple. And we're saying your decision, so Coinbase, for example, is saying, listen, judge, if you rule in favor of the SEC, you hurt our business. All these things happen. It's against the law. XRP holders from the UK that are part of this, they're saying my foreign regulator has deemed it not a security, and your decision, judge, shouldn't have any impact, right, on my asset. And so it's our opportunity for her, the judge, to learn just how big this decision is and how important it is, and so that she gets it right.
Our general counsel at our Fifth Avenue office, leaning back in his chair now thinking, oh, we should file an amicus brief on behalf of UPHOLD. And right now he's thinking, Oh my God, shut up, Martin. Don't talk about things you don't understand. What's the point? Why does Coinbase want an amicus brief? Why do they do this?
Well, Coinbase wants an amicus brief because they're worried. Here's the thing. And the reality is, and when this case first got filed, Martin, Doctor, I filed my lawsuit 9 days after the SEC filed its case. And I warned people, I said, listen, the thing that the SEC is alleging, it affects all altcoins. Absolutely. If they get away with what they're asking the court to do, it will equally apply to Cardano or Ethereum or anything. And I said, just because one part at the SEC gave a speech in 2018 that said Ethereum's not a security, that doesn't mean the new guy is going to think that. And in fact, the new guy is Gary Gensler. And Gary Gensler has basically said ETH is a security. He says only Bitcoin.
He basically says everything is a security unless proven otherwise. Let's go back to that. We have a big international audience on this call. So I put it to you that XRP is a security because it doesn't fulfill the fourth prong of the Howey test. I make that up. Explain what defines a security and why XRP is not one.
Okay. In the United States, there are certain things that are definitely securities. For example, a mortgage, a promissory note, a shares in Apple, shares in Uphold, right? That's a security by definition. But there's
what do they all have in common? What is the definition of security?
The definition of an investment contract is a form of a security, and that's what we're talking about. So the definition of a security via investment contract is an investment, right, of money into a common enterprise, and the investor is expecting profits from the promoter who promoted the asset. That's a security, an investment into a common enterprise where you expect profits from the person who told you to buy it. Basically,
so Ripple is a common enterprise. The product is XRP. I would be lying if I didn't want it to appreciate in price, and I would say that I'm relying on Ripple to help with that.
Well, and here's the thing is that Ripple isn't the common enterprise unless you buy it from Ripple, and Ripple says to you, we're going to look at our team, look how impressive we are. So yes, if Ripple sells to you, doctor, and says, look, this is what we're trying to do, then maybe it could be an investment contract, unless you're an accredited investor. Then there's exceptions to a security, and that would be an exception. An accredited investor is an exception. But what I'm saying is that when Ripple sells it to pays MoneyGram, and MoneyGram has XRP, and then MoneyGram goes to Uphold and sells XRP blindly to me on Uphold, what I bought is not an investment contract, aka a security with Ripple. Over 53% of all first-time purchasers of XRP never heard of the company Ripple. That is a fact.
Yes.
And so they bought XRP because it was the top 3 crypto asset and it was a cheaper price. They never heard of Ripple. So what I would come back to you, doctor, is say, how do you join a common enterprise that you've never heard of? How are you relying on the efforts of a company that you've never heard of?
I didn't know, right? I didn't buy shares in Satoshi Incorporated. I didn't buy shares in Vitalik Limited. I didn't buy shares in Ripple. I bought a digital asset. Okay.
You bought
and it became that special and that famous because it was very early on, as you said, 2015.
Right.
Is it an American phenomenon, or is XRP simply global at this point? And if it is a global issue, what is Gary on about? I mean, he has no right to tell the rest of the world what to think of stuff.
Well, that's what I said is arrogance. It's this arrogance that although these foreign regulators have done their job, but because Congress hasn't done ours, he's he's exceeding his jurisdiction. Why he's doing it? Well, he wants to pad his records, right? What's crazy, and I cite this in my brief, Doctor, is that in 2018, Gary Gensler said on stage at MIT that the market needed clarity, and he actually used Ripple as an example. He said, Ripple needs clarity. You fast forward 4 years, 5 years, and all of a sudden he's the chairman of the SEC, and now he says that it's been crystal clear all these years and that all of these assets are securities. Why? Because he is the chairman. He wants to get the credit for, you know, bringing all this technology under his scrutiny and taxing innovation, basically.
All right, great information. I hope that helps people, especially the newcomers jumping on board. Maybe you got into XRP recently. This is a great way to get filled in. That's all I have for the video, though. I want to say thank you. Please hit the like, share, and subscribe if you enjoyed the content, and stay safe, everyone.